Wonderful. So thanks again for joining us. My name is Karen Corman, and I have the privilege of being the Executive Director of the UIC Alumni Association. Welcome to the UIC Alumni Exchange Series. Whether this is your first program or your fifth, we continue to work to bring you a variety of topics and programs to help you explore, connect, and even escape from the everyday with a community of UIC alumni, staff, and faculty experts. You might hear me say this a few times today, but I encourage you to visit go.uic.edu/alumni exchange for the latest and greatest programming. And with that, I'm excited to start our program this afternoon, featuring a returning guest, our UIC John Marshall Law School professor, Steve Schwinn. Professor Schwinn joined us this fall, and he is a renowned constitutional law scholar. If you joined us last time, you know that you are in for a wonderful conversation, as Professor Schwinn is extremely knowledgeable, and we are so grateful that he has agreed to join us again today. Again, we encourage you to ask questions and use that chat feature and make this as interactive as possible. Thank you, Professor Schwinn, for being here. I'll turn it over to you to start the conversation.
Karen, thank you so much for that kind introduction and for having me back. It's a real pleasure and treat to be with you all. I do appreciate this opportunity. And Karen, I want to thank you and your entire team at the UIC Alumni Office, and Chris Beach and the entire team at the Alumni Office at UIC John Marshall Law School. It really is an honor to be with you all today. My name again, Steve Schwinn. I teach constitutional law and human rights at the UIC Law School. I've been there for 10, 12 years, something like that, and love my job and love interacting with you all and seeing friendly faces, even if only by Zoom. Before we get, I'd like to do just a couple of administrative things. First off, I'm going to ask everybody, if you don't mind, if you would please turn on your cameras. I really would love to see your faces. If you don't mind, please turn on your cameras. And then next, I hope that you will make free use of chat as we go along. And just while I'm thinking about it, I'm going to put my email in chat so that you have it if you want to follow up with me or ask me any questions after the session. Be happy to engage with you. It is a real pleasure to be with you today. When we put this session together, we, well, frankly, we didn't know exactly what we might be talking about, but we knew that we would be talking about the Constitution in challenging times because, after all, we are dealing with the Constitution in challenging times. But when we put the program together, I think we had no idea that we'd be in the middle of a second impeachment of this president and a second trial in the Senate, raising all kinds of interesting and very, very difficult constitutional issues and public policy and politics issues as well. And I'm hoping to engage with you on some or many of those today. We're hearing a lot of things in the public discourse that I think we can both clarify in today's session, but also indeed shape in today's session, because as we do with our Constitution and our common law constitutionalism, we shape the meaning of that document in our ordinary discussions every single day. And when we have opportunities and privileges like this to engage with each other about these issues, we literally are shaping the future of our very own Constitution. And so I take these conversations very, very seriously as not only an opportunity to learn about, but also to shape the very document that we're studying. And I hope that I can all energize you all around that theme as well today. So if it's okay with you, I think what I'd like to do is actually start with impeachment and talk about a couple of issues that have come up in the context of impeachment. What I can do is frame the issue, talk about some of the arguments that we're seeing one way and the other. What I'd really like to do is get your input on these and hear what you have to say about them. And as we go, if you have other topics or anything else that you'd like to talk about, please feel free to drop it in chat, either to me personally or to Karen personally or to the entire group, and we'll be happy to address it. I do have a couple of questions that came in before the session that we'll get to and loop around to before the end of the session. And if we don't, then we can certainly follow up on email. I'd mentioned impeachment. Let me just mention off the cuff a couple of other things that are going on that actually are I think we need to be paying attention to. So one is actually a question that I received before the session today, and that is, what about court packing? Can Congress and the Biden administration pack the Supreme Court or reconfigure the Supreme Court in reaction to some of the moves that we saw in the Trump administration? And we can have an interesting conversation about that. The Biden administration, as you may know, if you've been following this, has reversed course on a number of Trump administration immigration policies. And those are now going through the court. So just to be clear, Trump administration took a particular tack on immigration. The Biden administration is reversing course. And now that course reversal is actually subject to litigation, starting in a case in Texas that I think could be a very important one. We ought to keep our eyes on it. A couple of other things going on here and there. The issues on the Supreme Court docket are always interesting and important. The Biden administration reversed course on the Trump administration's position with regard to the Affordable Care Act in a critical case now before the Supreme Court, and we can talk a little bit about that if there's an appetite for it. But just to give you a flavor for all the other things that are kind of going on these days, underscoring that this is a constitution in challenging times. It's maybe an understatement. So let's start with impeachment and talk about a couple of things that have come up in the impeachment and the trial. And just to be clear about this, I want to, so often in the public discourse, we hear commentators and people conflate a couple of ideas that I want to be clear about how this works. So when we talk about impeachment, when we use that term colloquially, what we usually mean is a two-step process. The two-step process itself involves impeachment in the first step. That is, a person is impeached in the House of Representatives and then tried for impeachment and convicted in the Senate by a 2/3 vote. As a result of impeachment, the Constitution allows the Senate to remove an officer from office and to disqualify that person from holding future office. And that's what's at issue in the second impeachment in the Trump administration now. The House of Representatives, as I'm sure you know, issued a single article of impeachment for incitement for insurrection on January 6th, the day that the House convened to count the electoral votes, the Senate convened to count the electoral votes from the 2020 presidential election, and we saw insurgents surge the Capitol. Some say in response to President Trump's speech earlier that day, some say on their own, not in response to President Trump's speech. And that actually goes to one of the core legal issues in the case, whether President Trump's speech was protected by free speech in the First Amendment. But before we even get there, there's a really important question that President Trump's attorneys have raised and the House of Representative managers have addressed in their presentation. And that is, can Congress impeach a former officer, somebody who was once an officer, President Trump, but who no longer is an officer? The reason that's important is because obviously if the Senate can't do that, then the Senate can't move on this impeachment and really has no authority to impeach President Trump as a now private citizen. That issue went to vote in the Senate earlier this week, and 56 senators, a majority, which is all required for this particular vote, 56 senators, all 50 Democrats plus 6 Republicans, voted in favor of the Senate having constitutional authority to try the impeachment. And so they're hearing the single charge from the House of Representatives in the article of impeachment. Now, what the House has asked for is not removal from office, because removal from office is at this point an impossibility. President Trump is no longer in office, and so to remove him from office would be a nonsensical thing to do. What instead the House is looking for is disqualification from future office, that second penalty that flows from impeachment. But in order to get there, they have to get the 2/3 vote for impeachment and removal in the first place. And that sort of knot leads to another constitutional problem in the case that we can talk about here in a second. But before we do that, I want to say, interestingly, in the article of impeachment that the House of Representatives passed, they reference not only impeachment and disqualification of President Trump under its impeachment power, but they also referenced the 14th Amendment, Article 3. Now, Section 3 of the 14th Amendment is not something that we hear very much about. We don't really talk about it. And that when I describe it, I think you'll see why. Section 3 of the 14th Amendment allows Congress to disqualify any individual from any office, federal or state, in the United States. That's pretty dramatic. I'll say it again. Section 3 of the 14th Amendment allows Congress by a majority vote in both houses to disqualify any person from any office, federal or state, in the United States. Now, when I say that, that seems breathtaking. It is. The reason why we, the people, adopted that provision of the 14th Amendment is to allow, in the wake of the Civil War, Congress to disqualify rebels from serving in offices in the federal and state governments. And indeed, Congress used that authority at the time. Now, Congress hasn't really used that authority since then in any serious way, but the House of Representatives cited that authority, the 14th Amendment, Section 3, in the articles of impeachment against President Trump. What this suggests is that the House is pursuing this alternative method to disqualify Trump from holding future office. We haven't heard very much about this, and I think the reason why is because the impeachment, right? The impeachment process has garnered so much attention, and that's really by design. That's exactly what the House of Representatives wanted and what the House managers were seeking. A 14th Amendment process would get far less attention in the public. It would draw far less attention to the issues. And so the managers put that into the articles of impeachment to preserve that option, but we don't really see that exercised, at least not yet. It'll be interesting to see where this goes. So just coming full circle, the threshold issue in the Senate trial is whether the Congress even has authority to impeach a former officer, President Trump. If they have no authority, then the Senate obviously can't evict. Now, the Senate has said we do have authority, but not by the numbers that the Senate would need to convict. So it's still conceivable that enough senators could refuse to convict President Trump, not on the merits, but rather because they think the Senate lacks constitutional authority to even try a president for impeachment after a president has left office. And so these issues are still really important in the discourse. Let me tell you a little bit more about them. So when we talk about the Senate trying or Congress impeaching a former officer, there's a textual reason that the president's attorneys have said that Congress lacks authority to impeach a former officer. What they do is they point to the impeachment clauses in the Constitution, and they say impeachment allows Congress to impeach an officer of the government, not a non-officer or private citizen. And by that reckoning, reading the plain language literally like that, what they say is that means Congress can only impeach a sitting officer, not an officer who has left office. They say, moreover, that the result of impeachment is really are two things. One, removal from office, and two, disqualification from future office, what we already talked about. What they focus on here is the conjunctive and, disqualification and removal. And their argument is that if Congress can't remove the president, which by definition they can't because he's no longer in office, then Congress can't enact the conjunctive disqualification penalty against the president, because after all, those are conjunctive penalties, not disjunctive penalties. Now, what folks have said on the other side is they've kind of come back with both a textual argument and a practical argument in constitutional terms. What they've said is, look, the text read more broadly has to be understood to allow Congress to impeach a former officer. What they say is that if it weren't so, then an officer could escape impeachment simply by resigning office right before impeachment proceeded, or by leaving office right before impeachment proceeded. And if you've been watching the proceedings, you know that Congressman Raskin said what this in fact would lead to is a kind of impeachment-free zone in January for a president, right? And allow a president to do whatever a president wanted to for that month, but knowing that they would soon leave office and not be subject to impeachment. Moreover, opponents of this position in favor of the Congress's authority to impeach say, what we've done customarily is we've removed an officer first and then voted on disqualification, which means that the person has not been in office when Congress has moved to disqualify. And by definition, therefore, in the past, Congress has disqualified individuals from office who hadn't been in office. So we see a kind of interesting back and forth between the text and the practice of how impeachment actually works. Supporters of impeachment, the House managers, also look to history as a guide here. And history is a commonly accepted way to interpret the Constitution when we don't have a determinate answer from the text. What they say is, look, Congress in the past has impeached former officers. They point to a situation in the late 18th century where Congress moved to impeach a former senator, and they look to a situation in the late 19th century where Congress moved to impeach a former Secretary of War who had resigned right before the impeachment proceedings. President Trump team says in response to that, well, those really aren't great precedents for what the Senate is trying to do here. They're not great precedents because the votes weren't really there in those cases. They were kind of ambiguous. And even if they do stand for the proposition that Congress can impeach after an officer has left office, even if they say those are old precedents and we don't have to look to them as firm precedents today. And then finally, there's an interesting piece of this that you might have missed if you weren't paying careful attention to it. The person who's presiding over this is Senator Patrick Leahy, the pro tem president of the United States Senate, the senator from Vermont, not the Chief Justice. Now, the Constitution says that the Chief Justice shall preside over impeachment proceedings involving the president. Well, here's where we get into yet another constitutional knot. If the Chief Justice were to preside, that might suggest to some that Congress is indeed impeaching the former president and that Congress has authority to do that. The fact that the Chief Justice is not presiding, some have argued, is evidence that Congress lacks authority, because if Congress had authority to impeach the former president, then the Chief Justice would be presiding. We don't know why the Chief Justice declined to preside over the Senate proceedings. He was invited to, but he said that he didn't want to. The fact that he's not is potentially constitutionally significant in these ways. Now, at the end of the day, we don't have an answer to any of these questions. The courts haven't ruled on any of these questions. We don't have any firm or determinate language from the Constitution or from our prior history or practice to guide us in these areas. We really are in uncharted waters. Most constitutional scholars think that the House managers are right, that Congress can impeach a former president, but there are some who think that Congress cannot impeach a former president, or for a variety of reasons that even if Congress can, that Congress shouldn't impeach a former president. So just in sum, we're seeing a really kind of interesting back and forth over a unsettled constitutional question using commonly accepted arguments in our constitutional discourse regarding text, history, precedent, and even just the practical way that impeachment would play out. And so I guess there are some other issues with impeachment, but I think at that point, I'd really rather stop listening to myself talk and hear what you all have to say about whether you think that Congress can impeach former President Trump. Does anybody want to weigh in on that, and or even say if they find either of these sides' arguments persuasive or compelling?
You can see some fingers typing, so I'm not sure if people are typing in answers or if they want to come off and speak. The good thing is you're not getting graded on this, so there's no right or wrong answer.
It's what I love about so much of constitutional law. There's no right or wrong answer, but as I tell my students, there are right or wrong ways to make the arguments. So one comment, seems like a waste of time, more important stuff to do. A good number of folks have said that. In fact, some in the United States Senate have said this is just all a big waste of time. We ought to be doing more important things. What the House managers have said, and folks who support impeachment, is that it's important to make a statement, a public statement that rebukes President Trump for this behavior so that future presidents won't think that they'll be able to do it too. And let me just pause a beat on that point and explain why that's significant. In our constitutional tradition, so many questions about things like the separation of powers or presidential authority, or even to some degree, congressional authority, so many of these questions are unanswered and may never be answered by the courts for a variety of complicated reasons. Some of them fly under the radar. In some of these cases, the courts say they don't want to hear the case or that they cannot hear the case for a variety of different reasons. And some of these things just kind of come up and go away and we just ignore them. The reason why it's important is because we in our constitutional tradition use our institutional actors' prior behavior as precedent for what future actors can do. So much of what has happened in President Trump's administration, whether you like it or not like it, so much of what has happened that hasn't received significant pushback from Congress or the courts, so much of that is setting a precedent for what a future president can do. You'll remember at the beginning I had said it's kind of interesting now to see that President Trump took a particular tack on immigration policy, right, in a variety of different areas. We're now seeing the Biden administration reverse course on many of those areas. Now, some of the areas that President Trump acted in immigration policy were subject to litigation. The courts upheld some of those actions, they overturned some of those actions, and they declined to rule on yet other actions. When the Biden administration comes into office and reverses course, now we're seeing challenges to the Biden administration. But here's the thing. If President Trump took a particular immigration action, citing immigration authority that the president has in support of that action, and we favored that action, say, okay, that then sets a precedent for President Biden to do the same thing, but perhaps in a policy way that we don't like, right? Or vice versa. If we didn't like something that President Trump did, that may set a precedent for doing something that we do or don't like what President Biden may or may not do. I'm trying to leave politics out of this and illustrate a point that when we set precedent by our behavior, or our officials set precedent by their behavior, they're setting precedent not only for future presidents that will behave like them in terms of policy, but also presidents who will behave exactly the opposite way. And so when we make constitutional commitments about what we think is the appropriate scope of presidential authority, for example, what I tell my students is, keep an eye on the future, right? If you like what President Biden is doing today, because President Biden has such and such power under his immigration authority, say, well, then you better like a future president doing the exactly opposite thing, drawing on that same authority. Anyway, this is just kind of a long-winded way to say that practice forms a kind of precedent in our constitutional system. And what I think the House managers are saying here is recognizing that practice forms precedent in our constitutional system. If Congress doesn't categorically rebuke President Trump's behavior, then that behavior stands as precedent for future presidents. And the question that we need to ask ourselves is, do we want future presidents doing what President Trump did that's leading to his impeachment? It's a hard question. Really good point. Another one came in on chat. It seems that they think they can, but should when there's no real results. Yeah, Carla, that's a really good point, and I think a lot of folks are struggling with that. So just because, what I tell my students is, just because an institutional actor has constitutional authority doesn't mean that they should exercise that authority. We'll talk here in a moment about President Trump's free speech defense to the article of impeachment. And in some ways, my answer to President Trump is, well, just because you have free speech doesn't mean that you ought to exercise it in a particular way, right? Just because Congress has impeachment power doesn't mean that they ought to exercise it, particularly if there will be no practical result in terms of removal from office. But remember, the other result that could come from a valid impeachment is disqualification from future office. Now, here's where things get a little interesting. If Congress disqualified the president from future office using either its impeachment power, or remember, I had introduced this other authority that it has under the 14th Amendment to achieve the same result. If Congress were to do that, President Trump presumably could challenge that decision in the courts, and then the courts would have to decide if Congress validly exercised the power of disqualification. So ultimately, I do expect that a question like that would probably end up in the courts. Now, whether the courts would actually rule, I think, is a different question. And of course, how they would rule, I think, is anybody's guess, because we just don't have any rulings on anything like this. John asks, are saying that Congress can disqualify Trump even if the Senate doesn't convict him? John, that's exactly right. So what most people think, and I think there's good textual support for this, is that the 14th Amendment, Section 3, would authorize Congress by a majority vote in both houses through something like a concurrent resolution to disqualify Trump from any office, federal or state, that it wanted to. That could include the presidency, or it could include a judicial clerk in the city of Chicago courts. Again, that came from in the aftermath of the Civil War and the Reconstruction period, when Congress decided, and ultimately we the people decided, that we wanted to authorize Congress with the power to disqualify individuals, in this case former rebels, from holding office in the future. We haven't seen Congress use that authority in any significant way. And when it has, even after the Civil War, it's retracted it. So what it would do, how that would play out with Trump, I think, is in some ways anybody's guess. There are some different theories of how Congress would have to proceed using that 14th Amendment authority. But most agree that Congress could use that authority to disqualify Trump. The voters made a public statement they voted Trump out. Carlo, that's a great point too, and I love to talk to my students about this, because we tend to think, at least in law school, what we think is that constitutional accountability comes through the courts, either through criminal procedures or civil cases, right? But that's not the only thing that can happen. The primary way that we hold officials accountable in our democracy is by voting them out. And so you're exactly right. The voters made a statement, they voted him out. And if the voters decided that they wanted to vote against him, if he were to run again in 2024, for example, they could do that. Or if they wanted to vote for him in 2024, they certainly could do that. The reason that disqualification is part of impeachment and the 14th Amendment is that the framers thought that there are some individuals who could be so dangerous to our constitutional system, to democracy itself, that they shouldn't be trusted with positions in the government. And so it's that sort of motivation, I think, that's driving what the House of Representatives is doing here. But you're exactly right that democratic accountability is really the principal way that we hold officials accountable in our system. Now, having said that, Trump very well may be subject to other forms of accountability for behavior that led to his impeachment. For example, Georgia officials are now looking into the telephone call that Trump made to the Secretary of State in Georgia to find additional votes for him in the wake of the Georgia returns in the 2020 election. If that, well, I'll just say that's a very serious crime. And President Trump, as now a private citizen, would have absolutely no immunity from state prosecution for that crime and could be held fully accountable for it. Prosecutors in New York are pursuing claims against Trump and the Trump Organization for a variety of financial dealings that don't really have anything to do with the 2020 election. But again, my point is that there are other forms of liability and responsibility other than just voting officials out in our democracy. And I suspect we'll see more and more of those with Trump and the Trump team. This was sent to me privately. Article 3 of the 14th Amendment can accomplish the same. Why go through impeachment? That's a fantastic question. If Congress can achieve the same disqualification through Section 3 of the 14th Amendment, why go through impeachment? And why require this 2/3 vote in the Senate if they could disqualify with a bare majority? I don't really know why. And I've got to say, I'm a little puzzled as to why we're not talking more about the 14th Amendment remedy through all of the impeachment process. It is mentioned in the article of impeachment. It's right there. You can pull it up and read it yourself. So it's a little puzzling to me that we haven't seen more about this. If I had to guess, what I would suspect is that the House managers understand that the impeachment proceeding will bring a lot of public attention to this. And they want to bring a lot of public attention to this because they want to inform the public about the full range of activities that led to the events on January 6th. So there's a kind of public accountability, I think, that they're seeking in that way that they might not be able to achieve if they were working under their 14th Amendment power. The other thing that they might be thinking here is that the 14th Amendment really is an untested authority. And so they might have some hesitation in using it because they don't know that it would be as effective as disqualification under impeachment. Now, having said that, of course, disqualification under impeachment comes with its own baggage, right? The impeachment proceeding itself might not be valid, even though the Senate said that it was. And so there may be reasons for President Trump to argue that any disqualification that would result from impeachment is also invalid. So it's hard to know exactly what the House manager's strategy is here, but I suspect it's getting publicity for the impeachment. There is one other thing that Congress could do. Congress could issue a censure or rebuke of President Trump by a bare majority of both houses through something like a concurrent resolution. And there could be some value to doing that for those who favor accountability in this instance, but it wouldn't carry nearly the weight that disqualification would under impeachment or the 14th Amendment. I got to say, that's a really good question about 14th Amendment. It's really been puzzling me. I just don't know why it hasn't gotten more attention than it has. Other consequences, such as loss of presidential pension. Maradona, that's a great question. And this is really kind of interesting. Loss of the pension doesn't necessarily flow from impeachment. And the reason why is because Trump would still be a former president, and by statute, so the pension, the Secret Service detail, the office, the travel budget, all those are statutory grants of authority, I suppose, or grants of money that Congress has given to former presidents. And an impeachment wouldn't automatically take those away. Now, if Congress wanted to take those away, it could take other action and take those away, but it would have to revoke the legislation that authorizes those things in order to do that, or pass new legislation that says that those benefits don't apply to Trump as a former president. And so it doesn't flow directly from impeachment, but it very well could, and I suspect would likely flow through additional congressional action. Doris says, I think it's important to hear the many examples over the course of months and years in which Trump exhibited this behavior of promoting violence. It's scary to hear, But the reality of what's been repeatedly done, hopefully they'll be noted in history and to keep Trump and his followers from doing such things again. Wow, so many good points in that comment. Thank you, Doris. Let's see if we can unpack it. So toward the latter part of the comment, we talk about this being noted in history to keep Trump and his followers, or really anybody else, from doing it again. That idea is related to what I was describing earlier, that in our constitutional tradition, we count what actors have done in the past as precedent for what actors might do in the future. And that's especially true when neither Congress nor the courts has firmly rebuked, for example, a president. And so a firm rebuke here would be important for not setting a precedent that a future president could do precisely what President Trump did, resulting in the events on January 6th. The first part of the comment takes us in a somewhat different direction and actually makes a really nice segue for me to introduce the First Amendment free speech part of the president's defense to the article of impeachment. What President Trump is saying is that he can't be convicted in the Senate of saying things in his January 6th speech that led to the January 6th insurrection for a couple of reasons. First off, he says that his speech was not connected to the insurrection. What he says is he urged peaceful protest, walking down Pennsylvania Avenue, and said nothing about a violent insurrection. And indeed, later he says that he opposed violence. He says, moreover, that his speech, even if it did lead to or contribute to the insurrection, that it's protected by free speech under the First Amendment. What he's drawing on here is a tradition, right, that we have in our country of free speech. And we know that under the free speech clause of the First Amendment. But the reason that I say that way, tradition of free speech, is because we really do have a broad, by some measures, breathtaking free speech right in the United States. And President Trump is drawing on that tradition. Now, having said that, we also have some restrictions on speech. And so, for example, we restrict the speech that government employees can say, right? We restrict the speech that government employees can say because government employees are sometimes on the clock as government employees. And so therefore, they sometimes have to say the government's message. We sometimes restrict speech in other contexts. For example, when speech could be dangerous or incite violence or illegality. And the Supreme Court has actually defined tests for when the government can regulate speech that would lead to, for example, incitement. And so what the House managers have said is, look, President Trump was acting in his official capacity when he made these statements, so free speech doesn't apply to him the way that it would to an ordinary citizen who's not a government officer. But even if it does apply to him, they say it doesn't apply to the impeachment process. And what they say is it doesn't apply to the impeachment process because both free speech and impeachment are designed to protect we the people from the government. And the president ought not be able to use a free speech as both a sword and a shield here, is basically what they're saying. And then even if he can do that, what they say is, look, this is incitement. This is unprotected speech, according to the Supreme Court. And when President Trump uses language that incites people to insurrection, that's simply unprotected free speech, even if free speech does apply to him. So the reason that I mention all of this is because what the Trump defense is focusing on is just his speech on January 6th. And arguing, if we look at just the language of that speech and some but not all, some of the tweets that came after and the statement that he posted on YouTube after condemning violence, what they say is if we look at those things, We know that President Trump was not inciting insurrection. That's not what he was doing. And his language was protected by free speech. What the House managers are doing, in contrast to that, is not looking narrowly at Trump's statements on January 6th, but rather, as Doris suggests, at a whole range of behavior over time, right? And if you've been watching this on C-SPAN, you know that the House managers are putting into evidence things like Trump applauding when Texas drivers tried to drive the Biden campaign van off the road, or Trump's speech, Trump's language and speech and tweets that led to the attempted kidnapping of Michigan Governor Whitmer, and using all of these things to show that we have to understand Trump's speech on January 6th within this larger context, right? And so you've got a really interesting back and forth here between the House managers saying, let's look at the larger context and understand within this larger context that the January 6th speech really did lead to the insurrection. And the Trump managers say, or the Trump team saying, no, 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 that's not right. Let's look just narrowly at the precise language of the January 6th speech and parse that. And what they're saying is there's no way that that could have led to the violent insurrection on January 6th. So Doris, that first part, I think, opens up a kind of floodgate of issues here with regard to free speech and how to count prior speech when you're assessing something like whether a person is using inciting language now in a particular speech. And I think you hit the nail on the head with that. And that's a back and forth. I'd be thrilled to hear if anybody has any opinions on that, if they think the Trump team is right or the House managers team is right under the First Amendment, and what you think ought to be the scope of the First Amendment when we consider questions like that. I'm scrolling through chat. I just want to make sure that we leave time to get to as many of these as we possibly can. I don't, by reading chat, I hope I'm not suggesting that I don't want to hear your voices. I'd love to hear you pipe in orally if you'd like to. So just let us know if you'd like to, and we'll certainly unmute you. So KB asks, early on during Trump's administration, KB, am I getting the pronunciation right? Is it KB or Cabe? That's okay. Early on during Trump's administration, other Congress people such as Maxine Waters and others are on video in front of a crowd encouraging people to confront, harass, and bully Trump supporters. Why weren't they held accountable after this? Will they be? That's a fantastic question, and we're hearing a lot of folks say similar kinds of things with regard to Waters and other members of Congress who have made statements that in some ways sound similar to Trump's statements. And the one that I've heard most recently is folks are saying, and indeed you see this in some of the arguments that the Trump team is making before the Senate, that other members of Congress, other public officials have used this word fight, right? And so Trump used the word fight or let's go fight or we need to fight for our democracy or some such any number of times in that January 6th speech. And the House managers have said that's evidence of incitement to insurrection. What the Trump team has come back and said is, well, look, politicians use that term all the time, right? Fight. And so, and in response, what the House managers are saying to that is, yeah, but when you look at President Trump's use of that term in the larger context, again, going back to the earlier the comment about the larger context of President Trump's speech and his historical use of speech over time and the violence that it has led to, the violence that he has applauded over time, we take it in a different light. Now, you could make the same argument or not, perhaps, with respect to somebody like Maxine Waters or other members of Congress who were either commenting on or not commenting on some of the protests that we saw over the summer, for example. We've heard some arguments about that one way or the other and whether these are the same things. But at the end of the day, what the House managers have said is, look, let's just condemn all political violence. categorically, we can do that. But now we're focusing on whether President Trump incited insurrection. The other question in the chat is, will people like Maxine Waters be held accountable for those kinds of statements? And I guess what I would say is maybe they will. I think it depends largely on the facts of what happened in the individual circumstance. Given the larger context of what their statements conveyed, could they be understood to incite violence or insurrection? Or some other kind of illegality. And if they could be, and if there's a prosecutor who wants to go after them, and if they don't enjoy some sort of immunity because, for example, they might have said it on the House floor, then yeah, they could be prosecuted potentially. Michael asks, the 14th Amendment provides a possible route to disqualification, then why engage in the impeachment process? Right, and I think that's a great question, and I gotta say I'm really puzzled by it. I think the only answer that I can give is maybe what I stated earlier, and that is that I think the House managers are looking to impeachment because it's a higher profile process and will bring more attention to this. Carla asks, there seemed to be a lot of misinformation around the 14th Amendment. The press was saying that the vice president could invoke the 14th Amendment. Why? I didn't read that the vice president could invoke the 14th Amendment. There are some related things that I have heard. There is some misinformation and confusion around the 14th Amendment remedy. Most that I've read agree that Congress could disqualify the President Trump, under the 14th Amendment, Section 3. But they disagree as to exactly what that would look like. Most think that it would look like something like a concurrent resolution with a bare majority in both houses. But I've seen some other writing that suggests that there's something more required to trigger Section 3 of the 14th Amendment, something like necessary judicial review of congressional action. I'm a little dubious about that myself, quite frankly. And unfortunately, we just don't have any history or judicial interpretation of this, so we don't really have great guidance on it. But however you slice it, the vice president is not a part of that process. Now, the vice president could be a part of another kind of process that we heard about under the 25th Amendment. The 25th Amendment is an authority that the vice president and a majority of the cabinet have to remove a sitting president if a sitting president is incapable of doing the job. You'll remember Congress had sent a message to Pence saying you need to use the 25th Amendment remedy right away, or we will start impeachment proceedings. And Vice President Pence at the time declined to invoke the 25th Amendment. And that's what then triggered the House impeachment proceedings. The vice president could have invoked the 25th Amendment and gathered the cabinet together. They could have had a vote and discussion about whether Trump was able to do his duties as president, and even removed him at the time. There isn't anything in the 25th Amendment that would allow the cabinet to disqualify a president from future office, however. And so that's a uniquely impeachment or 14th Amendment remedy. Oh, Gabe, I'm sorry. Thank you. I just got that. Okay, Carl asks, what stops Congress from citing the necessary and proper clause to end any constitutional question about whether Congress can do anything against a person who previously held office? I love that question, and this is a great reading of the Constitution. I'm so delighted that we're looking at Article 1, Section 8, Clause 18, the necessary and proper clause, sometimes called the sweeping clause, which gives additional authority to Congress under its enumerated authorities. Congress probably wouldn't invoke the necessary and proper clause just because impeachment isn't in Article 1, Section 8, and the 14th Amendment authority to disqualify isn't in Article 1, Section 8. So just as a technical matter, it wouldn't invoke the necessary and proper clause. But what it would invoke, and what it has invoked, is something like the necessary and proper clause. The argument here is the text gives Congress certain authority, in this case, the authority to impeach, which means to remove and to disqualify. And that gives us a kind of sense of what Congress's authority is, but it doesn't really well define the limits of congressional authority. And when Congress has authority under the Constitution, as Carl said, under Article 1, Section 8, Congress also has some additional authority to do things that are necessary and proper to achieve its delineated authority. So here, the reasoning would be that Congress has the authority to do things that are helpful, in the court's language, to achieve its impeachment power. And Congress itself could determine that impeaching a former official is helpful toward its impeachment power and get to the same result. And so I love that question. And I'm really glad you asked it. And it does play, but just in a slightly different way. I don't want to impose too much on people's time. I know that we're running close to the hour. And so I'm gonna keep an eye on both the clock and chat. The January 6th speech, Michael writes, was simply the last straw. Trump's speeches and actions going back at least to midsummer 2020 incited insurrection. That's exactly what the House managers are saying. And indeed, likely how the Supreme Court would interpret the incitement doctrine that I had mentioned. In other words, we can look broadly in a larger historical context at President Trump's speeches and actions in terms of inciting insurrection on the 6th, as the House managers do, or we could look very narrowly at just the precise language that Trump used in his January 6th speech and parse that language to determine whether he incited insurrection, which is what the Trump team says we ought to do. The doctrine suggests that we would look more broadly at some broader context, but whether we would go, how far back we would go, or what context we would look at is a different question. We've seen the House managers look very broadly at that. And in fact, going back to some things that were happening in midsummer and even before with regard to Trump. Brian says, it's amazing that a duly elected commander-in-chief sworn to uphold the Constitution could negate the findings of our judicial system, that our constitutional election process was legitimate, berate duly elected officials who said that the election was the most secure in history. He kept repeating the lie, the election was stolen, even though all of our law enforcement intelligence were warning that violent hate groups would be descending on Washington, D.C. There must be consequences for the future of democracy. You know, well said. That's exactly what the position of the House managers is, and those who support impeachment. I think that captures that position quite well. There is something here that I want to focus on in the very last part of the comment, and that is that violent hate groups, that law enforcement had already identified that violent hate groups would descend on Washington on January 6th. The Trump team here is actually using that as evidence that President Trump's January 6th speech did not incite the insurrection. Here's the reasoning. This insurrection was already planned well before the speech. Even law enforcement knew it. And so therefore, anything President Trump said on January 6th could not have incited the insurrection, because the insurrection was already in motion before President Trump even stood behind the podium. And our FBI and law enforcement and intelligence agencies already knew that. Isn't that interesting? So, you know, my own take on the speech and the larger context of this, and indeed the question about whether Congress can impeach a former officer, is what we've seen so much throughout the Trump presidency, and that is moves that are sort of vague and hard to get our arms around. I think of them as squishy, right? Was President Trump's speech on January 6th, considering the context of other speech and behavior that we saw in the Trump presidency, was that an incitement to insurrection? I mean, yeah, in my view, quite clearly, yes, it was, but it's also a little squishy, right? When you look at the precise language that he used and how he backtracked afterwards. In other words, I think he's giving, in his speech, he was giving his future legal team at least something to work with when they made the free speech argument before Congress. And this is a trend that we have seen time and time again in the Trump presidency, not only with regard to speech, but with regard to policy, that is similarly squishy and kind of hard to get your arms around, to really hard to figure out what the president is actually doing, so that opponents of the action can file a legal claim to challenge it. And we're really seeing that put to the test, I think, with the free speech defense in the impeachment. Natasha asks, does incitement occur at one point in time, or can it occur over time? Well, that's a great question. So historically, in the cases that the court has ruled on, incitement itself occurs at a point in time, but the larger context of an inciting speech can be relevant. Now, the way the Supreme Court has ruled on these cases, we don't know exactly how much prior speech or how much prior behavior could be relevant to determining whether a speaker intended to incite violent behavior or illegalities. But we know that some context can be appropriate in that. The other thing that we know about incitement, and the Supreme Court's been quite clear about this, and the Trump team has drawn on this, is that a person can't be held responsible for incitement if the crowd overreacted to a speech. In First Amendment jurisprudence, we call this the Heckler's veto. If I say something to you that sounds like incitement, right, to you, but I've never intended it as incitement, nobody else would reasonably understand it as incitement, but you, because you're, excited and worked up about whatever I said, go out and commit some sort of violence or illegality, does that mean that I incited you? No, the court says probably not, because that would be a Heckler's veto situation where your action could actually have the effect of shutting down my speech. Now, again, I'm not sure that we even need to get that far in the First Amendment defense in the impeachment context, because, and we're hearing, you're hearing a lot of evidence about what Trump supporters were saying and how they were following Trump's orders when they were attacking the Capitol and following his orders when they pulled back. That might not be relevant in an ordinary criminal incitement trial. But remember, this is no ordinary trial, right? Trump's not being tried for criminal incitement under the United States Code. He's being tried for incitement to insurrection as a high crime or misdemeanor under the impeachment authority that Congress has in the Constitution. That's a very different thing. And so the defenses and the claims aren't going to work exactly the same. Even if not incitement was giving aid and comfort to the insurrectionists. Yes, absolutely. And that's part of the House manager's claim as well. The post-insurrection behavior, how that as circumstantial evidence shows that Trump really intended to incite violence in the first place, right? You might say that, going back to my speech to you, if I'm saying something to you that causes you to go out and commit an illegality, and then I know that you're engaged in the illegality, but I either urge you on or say nothing or both, that post hoc behavior may be a good indicator of what I had been thinking when I gave the speech in the first place. And that's the argument that they're making, and that is a that argument could potentially work in a criminal case. It can certainly work in the context of impeachment.
Professor Schwinn, I think we have one more question for you, although it feels like we could keep
Yeah, and
talking to you for hours.
Karen, I'm sorry, I lost track of time, so I'm sorry to keep y'all, but yeah.
Take the last question and then we can wrap up a little bit.
Yeah, of course. Are you thinking about the one in chat?
Yes, I saw one come through.
Yeah, so yeah, a lot of things going on. Yes to Sylvia and yes to Brian. I see and acknowledge both of those. And that's all part of the House manager's case. And then Judith asked, did the DOJ and HHS tell Trump, or HS tell Trump of the impending insurrection? Well, the evidence that we have suggests that Trump not only knew that it was happening, but by some accounts of people who claim that they were with Trump at the time, that he was pleased with it. And did nothing. And if we look at the timeline, the Washington Post did some really good reporting on this, and the House managers are setting it out in excruciating detail. If we look at the timing, it becomes clear that Trump not only knew what was going on, but made deliberate decisions not to do anything to help stop it. There were a couple of other questions, as I said, that were not directly related to impeachment that we didn't get to. And I think if it's okay, Karen, rather than imposing on everyone's time more, I think I'll just answer on email. That'd
be wonderful. Thank you.
And then if anybody has any additional questions or comments, I'd be thrilled to hear you on email. You have my email. I put it at the top of chat. So drop me a line and let me know. I'd be thrilled to hear what you have to say.
Well, Professor Schwinn, thank you so much for this incredible conversation and just engaging with our audience and all of your knowledge. We're so glad that you're on faculty at John Marshall, and just very, very much appreciate your time and sharing all your knowledge with us. Just to wrap us up real quick, thank you to all of you for joining us. Please join us again next Wednesday, February 17th at noon Central Standard Time for our next Alumni Exchange program, which will feature the UIC professor and head of the Department of Black Studies, Dr. Jane Rhodes. Dr. Rhodes will discuss the history of race in pop culture and print, film, and television over the generations as she presents Black Americans in popular media. As always, you can find recordings of all of our sessions at go.uic.edu/alumni exchange. Please be on the lookout for that quick survey. Please also send us questions, which we can share with Professor Schwinn if he was unable to get to them today. Thank you again, Professor, for being here and for sharing all of your knowledge. This has been a wonderful session, and we're so grateful for you. Thanks to all of you again for joining us, and we'll see you again in the UIC Alumni Exchange. Have a great rest of your day.
Thank you, Karen. Thank you, everyone.
Thank you.